Thanks, Jeanette. The first day hearing on the retirement fund's controversial bankruptcy petition proceeded in NMI District Court this morning before designated Hawaii Judge Robert Ferris. And a move to dismiss raises questions about whether the fund can legally be considered a person or private corporation that's even eligible to file the petition. Fund Bankruptcy Counsel Jeremy Coffey told the court that one purpose of the bankruptcy petition is to pursue collection on the NMI Superior Court's judgment against the government for years of unpaid employer contributions, an amount that now stands at $325 million. Another purpose, he said, is to align the fund's payouts to beneficiaries with its ability to pay. Coffey asked the court to consider, in particular, benefit cuts across the board of at least 58%, while granting the fund the ability to increase payouts should funding levels improve. One motion on the agenda today was to allow the fund to continue making full pension payments for at least the next 2 months. Last week, the fund created a private pension holding company and transferred about $13 million in fund assets as an insurance policy, Coffey said. Judge Ferris said since arrangements had already been made to continue pension payments, there seemed to be no urgent need to rule on the motion today and deferred action. Meanwhile, Hawaii-based attorneys Marjorie Bronster and Robert Hatch, along with CNMI counsel Steve Woodruff, appeared for anonymous retirees Jane Roe and John Doe. This morning, the attorneys filed a motion to dismiss the bankruptcy petition, challenging the fund's authority to file bankruptcy in the first place. Bronster told the court their clients have pending claims against the fund, its trustees, and the CNMI government, and she expressed concern about the fund's rush to bankruptcy before it was clear that the fund was even eligible to do so. The judge agreed that eligibility is a serious issue, but did not act on the motion to dismiss today, as the fund still has to respond. Coffey told the court and later KSPN that he was confident the fund is eligible. Roe and Doe attorney Woodruff, however, says it's clear the fund is not a person or a private corporation.
There's a very strong, I don't even want to say argument, because it's more than an argument, really, that they're not. Okay, they're created by the Commonwealth government. They're controlled by the Commonwealth government. The legislature passed a law forgiving the government of its contributions. The law calls them an agency of the government. The law says they're a public corporation and autonomous agency.
Judge Ferris also rejected the fund's motion seeking a broad injunction on any and all litigation against the fund, its board, or employees. The judge said such an order would be neither necessary nor appropriate and noted the normal automatic stay imposed on adverse litigation remains in effect. Other motions to allow the fund to continue operating as normal and for a time extension to file certain financial documents were granted. The next hearing is set for June 1st at 9:30.